I think it's a conviction. I don't. That the video was so damning. I was watching it with my wife, who doesn't follow any of this stuff as much as I do, and when you heard his voice, I mean, she looked at me in shock because she didn't realize it was coming. She didn't hear the prosecution's opening argument. She looked at me in shock and she was like, "Oh, he totally did this."
Welcome to the global phenomenon, Surviving the Survivor, where we're all just trying to survive in a rough world.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that brings you the best guests in all of true crime, and today is certainly no exception. All eyes remain on Walterboro, South Carolina, as the double murder trial of embattled former attorney, now disbarred, Alex Murdaugh, continues into the second week. He's accused, of course, of shooting to death both his wife, Maggie, and son, Paul. On Wednesday, Murdaugh sobbed in court. We saw some other tears on Thursday, and that is just a fraction of the story. Best guest here to break it all down today, Brett and Alice. They bring their unique perspectives as prosecutors to the hottest stories in true crime. They're the hosts of not one, but two weekly podcasts, the Prosecutors podcast and Legal Briefs. So make sure you're checking out both anywhere you find podcasts. And speaking of that, please follow us on Instagram, Facebook, Twitter. We are at Podcast STS. You can also find us anywhere you listen to podcasts. You can support us at Patreon. You can support us on YouTube as well. And as my 8-year-old daughter, and now my 7-year-old daughter too, says, because she got mad at me that I didn't include her, please hit that subscribe button and the like button. It gets the algorithm chugging. The 7-year-old said she's going to check. She knows how to get on to Surviving the Survivor, and she's going to check to make sure that I included her. So without further ado, thanks to both of you for joining us. Let's start with this. You don't really need a motive to convict. I don't need to tell you that because you're both attorneys. However, people are kind of giving the state a hard time here. They say that the motive that they are putting forth about trying to divert from these financial crimes might not be strong enough. Alice, your thoughts?
Thanks so much for having us on the show. You know, we always say this, you're right. It's not a legal requirement in order to convict that you need a motive. All you have to prove as the prosecution are the legal elements of a crime. However, that might be on paper. In reality, we all know the best story wins. The best story wins in life. The best story wins in court, especially with a jury trial. And so, you know, you can't make up a motive. You have to have some sort of story for it. But being a compelling storyteller is such an important part of being an advocate in the courtroom. So you can a good lawyer can make even the boringest of motives be exciting, and that is your job as an attorney. So the prosecution is hamstrung in the sense that they don't have to give a motive. But everyone recognizes that the jury wants a story. They want to understand how something so heinous and something so tragic can happen. How does a prominent, accomplished lawyer with everything going for him seemingly snap and kill his own flesh and blood? It seems like it just completely escapes all reason for the rest of us. But at the same time, while the prosecution wants to give you a full story, they can't make a motive out of thin air. They're relegated to the evidence that they have, and they have to make the most use of that.
And Brett, piggybacking off of what Alice just said, does the state need to firm up the story? I had a bunch of jury consultants on who were kind of griping about the same thing. Actually on both sides, saying that it started off unemotional, perhaps too technical, maybe even putting the jury to sleep figuratively, hopefully not in actuality. But what about this financial motive that they're building to divert from his financial crimes? He went ahead and killed his wife and son.
Well, I'll say a couple things. Number one, I find it a little strange, and I understand why people do it, that people are griping about the prosecution case and have they proved it? Oh my goodness. We have barely even got started. This has been a very slow moving trial. It sounds like the prosecution is going to put on a lot of evidence. So I would just say, hey, wait. For instance, yesterday was such a powerful day, and a lot of people were really amazed by some of the evidence that came in yesterday. Well, the day before yesterday, you didn't have that evidence yet. People were concerned. And then it does come in and it changes your perspective as far as the technical stuff. And then I do want to talk about the motive. People should remember this defense has made very clear that they are not willing to stipulate anything. They actually said that today, which means the prosecution is put in a position of having to do things like call the custodian of records for everything they do. And there is going to be a lot of boring in the beginning when you're getting the evidence in, because you can't talk about the evidence until it's admitted. So a lot of that boring was just necessary. It just had to happen. There was no way around it. And you're kind of seeing now the prosecution is really starting to hit its stride and really starting to bring in the things that are going to convince people that he is guilty. As far as the motive goes, I think one mistake people make that they shouldn't is they try and put themselves in Alex Murdaugh's shoes. And they try and imagine what would be a motive strong enough for me to do something like this. And I think that's a mistake because most people, fortunately, would never do something like that. And so you're never going to see a motive strong enough to kill your child and kill your wife. That's never going to happen. So you can't do that. You have to look at the evidence and you have to look at Murdaugh as he comes to you. And what you see here in this case is a man who had built this life on a lie. And that lie, on the very day that his wife and son are killed, is starting to fall apart. There was a lot of talk about that today, about how that was the day that the law firm came to him and said, look, there's hundreds of thousands of dollars missing. What happened? How are you going to explain this? And on the very same day that that's happening, his father, who had bailed him out financially on multiple occasions, is in the hospital and not expected to live. Those are two pretty big coincidences. He then, according to the cell phone evidence from yesterday, tells his wife, I need you to come home. She'd been at the beach. She wasn't even there. So he gets her there. And then if you look at the actual evidence, including his voice on the video, when he said he was never down there, even if for you, the motive never really comes together, when you look at all the evidence and you see all the evidence putting him there, and then you see the things that may have driven him in his mind, irrationally thinking as he was, it's never rational to kill your children and kill your wife. I think if you put those two things together, even if you can't imagine doing it, it shouldn't stop you from believing that he did it.
And that's a great point. We obviously very heavily covered the Brian Coburg case out of Idaho, where he is accused of brutally murdering 4 people. And we had all kinds of profilers on and forensic psychologists. And the one thing they say is, look, you can't get in his mind because you can't understand someone that's got that sort of sinister desire. And, the same, I suppose, would apply if it is true that he killed his wife and son. You can't really put yourself in those shoes and understand why he did it, because it's not something that 99.999% of us would ever think about doing. Obviously, finances, that I think it was a $700,000 amount that came into play today. And there was talk between Judge Newman and both sides about admitting more of these financial crimes and financial issues into evidence. How critical will this be to both sides, Alice? Some people are saying, look, and the defense was one of them, saying essentially, you're going to create 2 trials in one here. One about his financial crimes, one about the alleged murder of his wife and son. It'll complicate things. It'll make the trial much longer. It could go to the end of February, which I think it will anyway, or March. But how critical is this financial information to be brought into evidence on the side of the state?
So this is a pretty typical argument you'll see in any trial, and that's bringing in evidence of other bad acts. It's, in the federal court, it's the federal rule, Rule 404B. And you're always going to have those exact same arguments. The side that wants to bring in that evidence is going to say that it follows one of the exceptions. It's an exception to show his motive. It's an exception to show that he had the chance to do this crime. It explains the full story, and you can't possibly understand the crime he's charged with here without that other evidence. But these other bad acts, the other side is always going to argue exactly what you've said and what we've seen in court, which is that it's too prejudicial. It's going to create kind of the sideshow circus. It has nothing to do with the actual murder. And he's already been separately charged with those crimes, and he will meet his due process and the justice that he's due in those cases, but it shouldn't come in here. So I say that only to illustrate that this is not special in this case. This happens in just about every single criminal trial that you'll ever have, because we are not standalone people. We are full people with full lives, and there's lots of kind of strains, and you have to draw the line at some point in terms of what is relevant for the case before the judge, before the jury. And that's what we have here. So when you ask how critical is it, this is a fight that they envisioned. They've briefed this before trial. They knew this was going to be a fight from the very beginning. The fact that he was charged with multiple financial crimes and continues to be charged with financial crimes, both sides knew this was going to be an issue that the court would have to resolve. And they each had strong incentive to either keep it in or keep it out. It's not an end all be all, but you'll see that even if, let's say, the judge says, absolutely not, financial crimes are non-admissible, that is not actually a full bar. As the trial moves on, if the prosecution or different witnesses open the door to that type of testimony, the court can revisit that type of evidence. And so I also keep that in mind, is that as the court's ruling, things change within a trial. A trial is a true circus. There is no strong bar. I mean, it's a circus in every sense of the word. That's why it's so fun. That's why it's, as an attorney, it is like what you live for, because it is a live animal. It's a live breathing animal that changes day to day based on what people say. As coached as you are as a witness on the stand, you may let something slip that opens the door to allow certain types of testimony come in, even if the court has kept it out.
Speaking about coaching witnesses, that's an interesting point. How much are witnesses coached? I mean, take us behind the curtain there. How is it? Do they spend an hour together and say, hey, wear this, make sure you wear a tie that's blue, make sure your hair is parted on the side, don't say, say, yeah. I mean, how does it work behind the scenes?
Well, coaching's a dirty word, so we don't use that.
Okay, well, Brett, pick that up, Brett.
We prepare our witnesses for these kind of things. And so, in a trial like this, you've got a lot of witnesses. Not all of them are going to be prepared in the same way. You're not necessarily going to take the time to sit down with the custodian of records at the bank who's going to be introducing all the financial records, but really doesn't know anything. You're not going to sit down with them and go through every question. A critical witness, a witness that may be your most important witness, you may go through every question you're going to ask them multiple times. And it's not so much that you're telling them how to answer or what to say. That's frowned upon. But what you want them, you don't want any questions to surprise them, and you don't want any answers to surprise you. It's sort of the old adage of you really want to know when you ask a question what the answer is going to be. And you kind of saw that a little bit yesterday at the end of one of the testimonies of one of Paul's good friends. The prosecutor asked him, did you really know Alex Murdaugh? And the answer he wanted him to say was, no. I didn't know him at all, right? Even though he'd known him his whole life. And what he said was, yeah, I knew him. And that's and so the question just kind of falls flat and whatever. And you just kind of keep going. But that was obviously a question they had not practiced.
That's attorney 101, right? I mean, that's law school 101. You don't ask a question you don't know the answer to, right? Or no?
I mean, that's kind of a cliche. You do it all the time because you can't prepare for every single thing. And sometimes you think you see in the witness an opportunity that maybe you had not seen before. And I think that's what happened. He saw how emotional he was. He saw how willing he was to say, I'm 100% sure that was his voice on that video. And I think he thought it's worth taking the chance because it didn't hurt him. I mean, him saying that he really knew Murdaugh, I mean, people tweeted about it. It didn't really hurt him. The main part of the evidence was in. And if I can just say one thing on 404B, because I think it's really interesting and I think it's so important in this case, I think you put your finger on it. We've been talking about motive. Well, that's what this is. I mean, the 404B evidence here is going to motive. And motive is a reason you can bring this in. And Alice was talking about opening the door, and you actually saw that yesterday. The defense, they're in a difficult place because the argument they want to make is essentially this family man who loved his children and his wife more than anything. He would never do this. And they want the jury to be thinking, yeah, there's just no way he would do this. I know there's tons of evidence. But we're missing something because there's no way he would do this. So they have to paint him that way. And the prosecution was able to ask a question of one of the witnesses going through, okay, so you knew him really well, and he loved his kids and he loved his wife. Did you know everything that was going on with him that day? Did you know, for instance, that he had just been confronted by his law firm with $700,000 that were missing? The defense objects. The court overrules it. And what do they say the next day? The next day, the judge says, look, we're still trying to decide this whole 404B thing, but you opened the door. When you started asking all those questions, when you said things like, can you think of any reason that he would kill his kids? You opened the door for the prosecution to bring this in. So it's like Alice was saying. Sometimes, even stuff that initially wouldn't come in, the defense, through its own questioning, allows the prosecution. They have a right to rebut that when the defense is making that argument over and over again.
It's all a chess game here, a high stakes chess game. Alice, to you, we keep hearing the words probative versus prejudicial, and now we're hearing it in regards to his financial crimes. Can you explain the difference and on which side you think these financial crimes lie?
Yeah, that's a great question. So, those are terms that we don't use necessarily all the time in daily language, and the legal terms may have different meanings than what you think. So, prejudicial, of course, we've heard that word a lot, but prejudicial for the legal sense is just saying that this piece of evidence, even if it can go to, say, motive, it is so damning that the hearer of that evidence can't only look at that piece of evidence for, say, motive. So, rape, for example, is a very classic example of more prejudicial than probative, right? The fact that someone has committed a rape sometimes is so powerful and so has such a negative connotation that the jury can't hear anything past that. They can't hear anything other than rape must mean bad. And so an attorney may argue that's such a prejudicial act that there is no way you can use that piece of evidence because anyone's going to hear this person's capable of doing something so heinous. They're guilty of anything. I don't care what it is, counterfeiting a check, even if it has nothing to do with rape. It's just so prejudicial. So that's the legal term of prejudicial. Probative is saying, does it probe into the exception that the rule allows? Is it probing into what the motive is? So you have a piece of evidence and you want to show that it is more probative. So it goes to the motive more so than it's going to be prejudicial against the person. A thing like financial crimes, you could see how at least the prosecution will argue he didn't kill anyone. Like these other crimes, he didn't kill anyone. He didn't do anything where on its face it's so heinous that the ordinary person on the street who hears it will automatically make up their minds as to the innocence or guilt of the man based on that other crime. So that's the argument you would make in court.
And Brett, keeping the chess game analogy in play, who's winning the game so far? Your side, the state, the prosecutors, or the defense, in your opinion?
Well, I mean, I go back to what I was saying earlier. I think it's a little dangerous to say who's winning when you've barely even started. It's kind of like counting votes in an election when all the votes are cast, but somebody's winning because we haven't counted all the votes yet, right? It's kind of the same thing. I mean, look, in my opinion, and we're on neither side in this one, we're keeping an open mind. And in my opinion, the video evidence from yesterday was very damning for Murdaugh, however you pronounce his name. They pronounce it differently every day for multiple reasons. The first is one of the things the prosecution put on is they put on his statement right after two statements, the statement right after the murders and a statement a few days later. In both statements, he said he ate dinner with his family. He fell asleep. They went down to the dog kennels and he never saw them again. He never saw them after that. And he was adamant about that. Never saw them after dinner. Well, now we know that's not true. We know that he saw them down at the kennels. And because of the timing that was done through the forensic search of the phones, and because of the video and when the video was recorded, and because of when those phones lock and never open again, we know that they were killed probably within 5 minutes of that video being taken. So within 5 minutes of him being where they were killed, that video was taken. And the other thing that would have had to have happened He doesn't turn on his car until after they would have been killed. So that means imagine a scenario where he's down at the kennels with them, there with the dogs, and then he's like, okay, I got to go see my mom, and he leaves. And someone comes in 3 or 4 minutes later and shoots Paul twice with a 12-gauge shotgun and shoots Maggie multiple times with a AR-15. You would also have to believe that Paul was awake on the property and didn't hear a thing, didn't hear a gunshot, right? I mean, that's what you have to believe to think he's innocent. And that's one of the things we talk about a lot. What do you have to believe to think that the state's got this wrong? Reasonable doubt. What is reasonable? And is it reasonable to believe that he was down there 5 minutes before this happened and has nothing to do with it and has no knowledge of it? I mean, that's really powerful, and the state's case isn't even done yet. So to me, the defense has a lot of work to do, to the extent I think they almost have to put him on the stand. I think he almost has to get on the stand and explain why did he lie to investigators about being down there, because he was clearly down there. And you'll notice on cross-examination, they didn't really challenge that. They didn't really go and try and say, are you sure that was his voice? Could that have been someone else's voice? They didn't even do that because they know you listen to it and it's obviously him.
Do you think that Harpootlian will put him on the stand? Do you think he's going to be cornered into a position where he has to succumb and do that?
I mean, it is a dangerous thing. The only reason I think in this case you might is because his own words are so damning to him. And I feel like he needs to explain them. And it's not that there's not an explanation. I mean, he could say, look, I'm a lawyer. I've represented people before who've been accused of murder. And I knew when my family was found dead in a place I had been 5 minutes before they were killed, I knew they would assume it was me. I'm the husband. Of course they were going to assume it was me. So I lied about that. And I feel terrible about it. And I feel guilty. I have survivor's guilt because I wasn't there when they died, right? I feel like he has to say something like that. Otherwise, all you have is him saying, I was never down there. And then his voice proving he's lying.
Apparently he was a really crappy lawyer, albeit a lawyer. But Alice, to you, just to pick up on that, because it's, as we say in news, a bombshell thought/claim from Brett here that Alex Murdaugh could take the stand. Do you see it happening?
So obviously we all know that it's your constitutional right that you can plead the fifth and you do not have to take the stand. And there will be, if he does not take the stand, there is always a jury instruction given by the judge to the jurors that says you should not read into the fact that the defendant has not chosen to take the stand, because we all have that right. With that said, in every trial Brett and I have ever done, it is always an open question whether the defendant will take the stand. And oftentimes it is the defendant wanting to take the stand and the attorneys knowing in that case the best interest for the case is for the defendant not to speak. And that's because we face a lot of defendants who think they are smart enough to be able to talk their way out of whatever allegations have been spewed upon them. However, just like Brett said, in this case, he spoke so freely and so long and so definitively right after the murders that his own words have essentially crucified him. And it is very hard to get over those words without the same person speaking those words giving some explanation. And look, Brett's obviously a very good lawyer. You just heard him give the explanation that Murdaugh should make when he gets on the stand. And even as I'm listening to him, I know that's a bunch of, baloney that Brett's saying, but he said it really well. Now, is Murdaugh that good of a lawyer? I don't know. And it puts his entire likability and his ability to speak to the 12 jurors on the stand, because it's really, it's about his words, but it's also about his likability. And after, like you said, another month of trial, the jurors, based on the evidence, probably is going to hate him. And you need to wait it day by day. I mean, I really mean that, right? You have people on your trial team whose job is to watch the jurors' faces. And there's a reason for that. People are really bad at poker faces, especially when you sit in court for 10, 12 hours a day. It's hard to keep all of your emotions in. And you're looking at those jurors' faces and you're trying to read what they think. And if they have already made up their minds and they hate your guy, I mean, it is a massive risk analysis that you're taking in. So I think it's something that they're assessing day by day. Even if they get to the very end and they have no other defense but to put him on, but they see the hatred burning in 12 people's eyes and that it's only going to further crucify him, they're in a rock and a hard place. and they may choose not to put him on, and that could be damning, but it might not be as damning as putting him on the stand.
And Alex,
And
let me
one
ask you
other
a question.
thing. Okay.
Go ahead, Brett. Go ahead.
Well, just one other thing I was going to say about testifying. We talked about opening the door. Testifying in your own defense is the ultimate door opener. If you do that, so much that otherwise wouldn't come in does come in, because now you're making statements and the prosecution can use evidence to counter that. So that's the other danger. It's not just he might not be convincing. It's also some of this evidence they're fighting so hard to keep out. If he testifies, it could come in. But this is not Harpootlian's decision. It's his decision. And if Murdaugh is like, I am testifying come hell or high water, that's what's going to happen.
Alice, if you're one of those people whose job it is to be monitoring the jury's faces, and let's say you're in court today and you're starting to see that anger seethe, let's just say, we don't know that that's happening, but the eyes are beginning to turn red. What do you tell Dick Harpootlian? What do you say to him?
I mean, you play the long game, right? Obviously, the prosecution's job is to put on the evidence first. So we have cross-examination where we get to hear the defense's story, but you're only hearing it piecemeal, and it's trying to poke holes into the prosecution's case. So of course, we all have kind of these biases. As you hear a story, you're likely to believe what you hear first. We're hearing the prosecution side first. And so the defense does have a chance to come back as well. We're not, if this is chess, one side is moving and the other side hasn't really had a chance to move yet. But that's a really good point that you make, because the jurors read into everything. Obviously, they're listening to what's coming out of the lawyers' mouths, and they're listening and seeing the evidence, but they're watching everything. They watch what you wear, and I don't just mean the defendant, not just Murdaugh. They're watching what the attorneys wear. They watch things like how the attorney touches their client or doesn't touch their client. That's why, honestly, you see a lot of defense attorneys physically touch their client, talk to them as if they are just cohorts rather than a client attorney sort of relationship, because they want to convey to the jurors, this is a man who could be your brother, your father, your friend. This is not some person who is so outside of society that you shouldn't have guilt or a lot of heart-wrenching internal turmoil when deciding his ultimate fate. And so every single day is an opportunity for that. And people grasp onto the strangest things. We hear a lot about his son, Buster, and his girlfriend and his brother coming in every day. That's not just for show. Of course, they're there for him, but that matters to the jury. When you have a defendant who has no one supporting him, they take note of that. Oh, your own family's not there for you, then why should I even believe anything you say? And so all of this, it's part of a choreographed dance. Obviously, there's the human aspect of it, but know that it's a minute by minute sort of choreographed dance, and all of it factors in, and you are constantly changing your strategy. Maybe he'll start wearing more sweaters to look like Mr. Rogers. I've seen clients do that. I've seen defendants do that. Throughout a trial, they start out in a suit. And then as the weeks go on and they realize that, it's a white collar crime and the jurors are just hating this person who seems like a narcissist, you see they change their appearance. They look a little more humble, disheveled hair, Mr. Rogers sweater vest. I'm not kidding about that, right? They're hoping that they can reach the jurors in any way possible.
Wow. Trial intrigue. So, Brett, we were talking earlier a little bit about these videos, and obviously we just saw this new video, the Snapchat video. There's been all kinds of confusion. The Snapchat video is actually taken around 7:38 p.m., a little over an hour before the murders happened, and Alex is seen wearing a different shirt and pants than when he was interviewed by investigators. I talked to a defense attorney in the last episode. He says, look, it's South Carolina, the southern part of the state, in June, very humid, very sticky, very possible he could have just changed his clothes. That sounds a lot like a criminal defense attorney. What say you as a prosecutor?
I don't think it's very significant. I mean, it's funny the things that people grab onto. And we spent all this time arguing about in that one recording whether he said, I did him wrong or they did him wrong. I forget the exact language. And it's like, what difference does it make? It doesn't actually matter. He's not confessing there. And I feel the same way about the clothes. I agree completely with the defense attorney. And if I got on the stand and I was him, I would say, when I left the kennels and walked back up to the house, the first thing I did was change clothes. I threw on some new clothes because I was going to see my mom and I didn't want to be all sweaty and gross. And I jumped in my car and I took off. And that's what I was doing for the couple minutes between when I left the kennels and when I turned on the car. I wasn't killing anybody. I was changing into some new clothes. And yeah, I think a lot of these things, I get why the prosecution's doing it, because it is a fact that he was wearing different clothes when the police showed up. But it's pretty easy to rebut. Now the thing is, in order to really rebut it, he needs to testify, right? I mean, the defense made sort of the points that you're making, and they make it through cross-examination. I mean, they ask questions like, "This was June in South Carolina, right? Couldn't it be that somebody just wanted to change clothes?" They do that, but hearing it from his mouth would be more powerful. But he can only do that if he does decide to testify. And the weird thing is, for the defense, I feel like sometimes these are gifts, because the defense can try and get the jury to focus on things that don't actually matter. So, think of the OJ case. The glove don't fit, you must acquit. There was a mountain of evidence against OJ, but because the prosecution made that one mistake, it allowed the defense to focus on that. And the jury could tell themselves, he's right, glove didn't fit. All that other evidence, I'm just not even going to worry about that. And I sometimes think about with like the recording of, did he confess? And the prosecution, they put the SLED agent on the stand and get him to say, I did him bad, or I did him wrong, or I did him so wrong. I can't remember the exact words. And there might be a juror who's like, I didn't hear that. I heard they. But man, they made a big deal about that. Does their whole case hang on that? Well, if I don't agree with that, maybe he's not guilty after all. And that's one thing you have to be careful of when you're presenting the prosecution case, because there's much stronger evidence than that, to me.
And so the other video, I think, was taken around 8:48 p.m. The other interesting thing here is I believe the coroner puts the murder somewhere between 9:06 and 9:30 p.m., but the state says the murders happened at 8:50 p.m., if I'm correct about that. And this other video, which I call the dogtail video, was taken around 8:48 p.m. And on that one, Alice, you can hear Alex Murdaugh's voice, and two witnesses on the stand said they're 100% certain it was his voice. I assume from the state's perspective, that is a much more damning video, because now you've got Alex Murdaugh's voice placed very close to the scene of the crime, very close to the time the murders happened, correct?
Yeah, I mean, the fact that the coroner's time is slightly different from the prosecution's is okay. And here's why. The coroner is trying to make like a medical estimate based on the way the blood's congealed and whatnot. The prosecution's like, we're just looking at movement of your phone, right? Like if you have your phone that's being turned on, turned off, and you have constant movement with it, all of a sudden it goes dark, that's certainly strong evidence. You don't have to be a medical expert to recognize that there's been a change in circumstances for the user of that phone based on a pattern shown in the forensic analysis of the phone. And so they don't have to get it down. That's a 15-minute difference. That's not a huge amount of difference, especially when you're talking about this property and you're talking about the lies that Murdaugh perpetrates right after the murders. So I agree with you that, I mean, that was the bombshell, the tail video, and putting Murdaugh right there in the kennels where obviously both his son and wife were found dead. I mean, Brett laid it out perfectly there. It puts him right there. Why is he there? How did he not hear anything? Why didn't he say that earlier? And then why, if he's in this, I think it's very compelling evidence, because all of us have phones these days and we communicate based on our cell phones. He was clearly in a back and forth with his friend, Paul was, about this dog, because within, seconds, his friend is telling him how to take a different picture of that same tail he was just taking a video of. If you're in that kind of midstream conversation and it gets cut off, that's powerful evidence that something happened. There was an intervening factor as to why that conversation stopped. And who was there of the three people that we heard in the video who could have perhaps caused an intervening factor? Well, only one of them survived, and that's Murdaugh. That's incredibly powerful.
And Brett, do you think that it will be digital forensics, aka this cell phone evidence, that is potentially Alex Murdaugh's undoing?
I do. Honestly, I'm not even sure why the doctor would be that specific. There's no way he can tell with that kind of specificity about when this death happened. But the phones are really powerful, like Alice was saying. They're in this constant. The Paul conversation, I mean, that testimony from Rogan was so powerful, because Paul They tried to do a FaceTime video so he could just show him on the FaceTime video of the dog, and that didn't work out. So then they decide to record this video that he's supposed to send him, which he never sends him. And they are in this constant communication. And Rogan, he sends that email asking for him to take a picture of the dog's tail at 8:49 and 35 seconds. And he never reads that. Paul never reads that, even though he's been in constant communication with him. And that tells me that either the murder had already happened by that point, or it happened very soon thereafter. And if that is Alex Murdaugh's voice on the video, which everyone seems to believe it is, that's literally 4 minutes after the end of that video. So to believe he didn't do it, in 4 minutes, he had to have gotten away from the kennel such that he wasn't killed. And once again, oh, by the way, didn't tell the police when they showed up, I heard gunshots, but we're in the middle of nowhere, South Carolina, so I didn't think anything of it. I just thought somebody was night hunting hogs, which they did. That would have been a much smarter story for him to tell. People are always shooting hogs at night around here, so that's just what I assumed it was. But the fact that he doesn't say anything like that, his statements to the police are so damning. They are so damning because they are so inconsistent with what you can see and hear with your own eyes.
Creighton Waters better get Brett and Alice on the case quickly. So let's get into some of the particulars here, and then we'll wind it up with some questions from STS Nation, the best audience in all of podcasting. So on Thursday morning, excuse me, Judge Newman began the day by explaining why he allowed the prosecution to ask the last witness on Wednesday about Alex's financial crimes. Judge Newman says that Murdaugh's defense team opened that door by turning Rogan Gibson, the friend of Paul Murdaugh, into a character witness. For those of us who are not attorneys, Alice, can you streamline that, strip it down, and explain what Judge Newman was saying here?
Sure. So there's fact witnesses, there's expert witnesses, and there are character witnesses. They don't all have to be in separate silos. And when you have, clearly Rogan was called as a fact witness because he was the one who was in constant communication with Paul. His very texts were the ones that were not read. He was the one speaking with Paul right before Paul died. And so the prosecution called him for the factual testimony that he had to give. What the judge meant when they said that the defense turned him into a character witness was that a character witness is someone who testifies to your good character, and good character has nothing to do with the facts of the case, but rather you are such a good, husband, such a good father that your character prevents you from having committed the crime that you've been accused of. So anyone can turn into a character witness. But the fact that the defense was asking Rogan about questions of Alex character meant that they opened the door to show there were other reasons, other things about his character that this particular witness may or may not have known about. So that's exactly what Brett was saying earlier. If you have a character witness saying, well, yeah, I know him as a loving father, as a loving husband. He coached our, little league games. He was there for every school play, the consummate father, the consummate husband. You're allowed to then challenge that. That doesn't have to stand unrebutted. The whole point of a trial, why you have direct and then cross-examination, is that you get to challenge what is said on the stand. And to challenge that properly, you have to be able to rebut that type of character witness. And that financial information, the financial kind of downfall, goes to Murdaugh's character. So that's what the judge means, is the defense wasn't challenging his factual testimony, but was rather asking Rogan to talk about the man that Murdaugh was. And by doing that, they've opened the door to allowing this financial information to come in, because that financial information didn't have to do with the actual shooting of Paul and Maggie. Rather, it had to go to the character of who they are accusing of doing the shooting.
And Brett, on Thursday morning also, Judge Newman then said later in the morning that he wanted to hold separate hearings where the lawyers can discuss without the jury if any of this financial crime evidence will be admitted. When do you think we get a decision on this, and how does he have to kind of split the playing field here and give concessions to both sides?
Well, I think that's exactly what it'll end up doing. A couple things. This number one, the prosecution smartly is asking for the world. They want every single financial misdeed he ever did to come in, and they're asking to put on every witness who could possibly talk about that. That's not going to happen. But what's also not going to happen, it's funny because the defense out of one side of their mouth are like, there's no way. He's a loving husband. He couldn't have done this. He's a good man, a good father. What in the world? What reason would he have to do this? And then out of the other side of their mouth, they're like, but anything bad he did that might make you question those things, that's completely irrelevant and shouldn't come in because it's totally prejudicial. And I'm sorry, that is such a loser argument. And it's particularly a loser argument about what happened on that day. Now, look, Alex Murdaugh has done a lot of bad things, and some of it's not going to come in. Everybody knows about him stealing from the children of his housekeeper, who I hate to even call her housekeeper because she was more like a member of the family who raised the children who died on his property. And he assured her children that he was going to take care of them, and then he stole all the money. That's a really bad thing. That's a really prejudicial thing. That's the kind of thing that if you're a juror, you hear it and you might say, this guy's a scumbag, and I don't really care if he did this or not. I'm finding him guilty. And that's exactly the kind of evidence you don't want to come in because you don't want it to prejudice the jury. I don't think that evidence will come in. But the $700,000 that he stole, that his own law firm found out about that day, that's going to come in because it's tied directly to the murder. When this 404B stuff, you got to tie a bridge. It's not evidence of the murder by itself. You have to connect it somehow. What is the connection? And we've talked about motive and we talked about character. And those are two connections that you can draw here. And yes, I would be absolutely stunned if after all this, the judge doesn't let some of it in. He's doing it the way he's doing it. It's called in camera, or there are different words for it. But basically, once this comes out in front of a jury, there's no unringing that bell. There's no putting the cat back in the bag, whatever your favorite cliche is. You can't do that. So he has to hear the evidence first without the jury present. There has to be enough evidence to show that it actually happened, because you certainly don't want bad acts coming in that you can't even prove. That's a really bad thing. So that's why you're seeing so much of this laying the foundation for the fact that Murdaugh actually did these things. That's the first thing. And then once you've established that, then it's more of sort of a legal argument. You see them citing a lot of cases about why those bad acts tie in directly to the case and should come in because they are more probative than they are prejudicial, going back to those words we just talked about. And when you're thinking about that balance, the more probative it is, the more prejudicial it's got to be not to come in. And that stuff about the financial problems he was having on the very day his wife and child were killed. And oh, by the way, why was it that all that was coming out? Why was the law firm looking into that information? Because they had to release some financial information related to a lawsuit about a boat crash in which Paul was the driver. And to me, if you want a reason why he would do something like this, his whole world is collapsing, and Paul is in some ways responsible for it. Not saying that's rational, but you can imagine a man in his situation thinking that.
It makes a lot of sense the way you just framed it, for sure. Speaking about that, it was $792,000, Alice. And late Thursday morning, a woman named Jeannie Seckinger testified. She is the CFO of what was Alex Murdaugh's law firm, and I believe they've changed the name since then. Basically, testifying that Alec had sent her an email claiming that missing money was in a guy named Chris Wilson's trust, who was one of Alex Murdaugh's best friends. Then he got sidetracked during her conversation with him, as we talked about briefly, because his father was terminally ill. Seckinger, the CFO, says that changed the mood. And then later on, Seckinger says that the lawyers met and discussed their findings, and it showed that Alec most likely stole money, and actually, in one instance, I think he was even depositing into some sort of fraudulent account. To Brett's point about him being, and I quote Brett here, a scumbag, could it be something like this that sways a juror into saying, hey, this guy is a thief, he's a liar, he's a cheat, maybe he's also a killer now. I don't know. Could it influence a jury to that extent?
Of course it could, and that's what goes into the probative versus prejudicial weighing analysis. What you've articulated right there is exactly what the prejudicial prong is trying to look at. That's the exact argument why you would want to keep out the information that someone who's a liar and a cheat and a scumbag is also a killer. But that is not what the law requires, right? The law requires that they are a killer in and of themselves, and the evidence in this case has to show that he killed Maggie and Paul. But like we said at the very beginning of this episode, it's difficult to know how anyone can suddenly snap and kill their own flesh and blood. And so jurors are human beings who have to try and understand the facts before them, even if they themselves could never put themselves in those exact circumstances. So even though we all recognize what you just said, as improper as it is in the law, is true, it's hard to keep those things separate, right? That a liar and a cheat could then also do something as bad as this. The prosecution has to argue against that, saying, no. Financial crimes is such a large leap to killing. And that's not what we're trying to show here. We are not trying to show that because he's done other bad acts, it makes him have a higher propensity to do this terrible act of murder. They have to say it goes to show, and you can see how it's kind of this. It's two sides of the same coin, right? And it's not improper to argue either of these things. It's a very difficult question because we are all complex beings, and also the hearer of this evidence filters it through their lens as well. And so the arguments you've articulated are exactly what the judge has to weigh, and why likely, as Brett said, there's going to be some splitting of the baby, so to speak, because it is not a slam dunk for either of those. You can see both of those arguments having sway.
Again, kind of the BTS, the behind the scenes, and I'm fairly new to all this too. Brett, I was going to ask a totally different question, but in light of what Alice just said about the judge ultimately having to make this decision, take us into the judge's chamber. What goes on with a judge in a trial like this? I know you're not a judge, but you've been around him long enough. How does he weigh something? Like, what does he look at? Who does he talk to? How does he figure this all out?
And Alice and I both have had the great benefit of clerking for district court judges who did exactly that and had to make those decisions. So we actually got to see how the sausage is made.
Mm.
And look, what the judge wants, he wants a fair verdict, an just verdict, and he doesn't want to have to do this again. And all three of those things are very important. And sometimes we call the last part protecting the record. And sometimes there's a thumb on the scale where actually the prosecution has a harder time. Alice and I last year tried a really big case. It took a month to try. It had 100 witnesses, 2,000 exhibits. We wanted to bring in 404B evidence, not unlike what we're talking about now. And the judge was like, I'm going to reserve ruling until the end, and then I'll make a decision. And at the end of the trial, after a month, he asked us, do you still want to bring this in? And we wisely said, nah, we're good, right? Because we didn't want it to come in at that point because that's an appealable issue. That is the kind of issue, and that's going to happen in this case. If this evidence comes in and Alex Murdaugh is convicted, an issue on appeal will be whether or not that was the correct ruling by the judge to allow this evidence in. So I think what you're going to see from him, he's going to talk. I mean, he's talking to his law clerks who are young, smart lawyers who are helping him. Obviously, he knows way more than they do about the law, but they're helping him look at the law and look at other cases and see what the Supreme Court of South Carolina's done. You heard him talk about that. He talked about a case where a conviction was overturned and why it was overturned and how he was going to avoid that from happening to him. He talked about one of his cases where he let in 404B evidence and the conviction wasn't overturned. And so he is going to try and craft an order that is narrow. Like I said, I think there is a lot of things that Alex Murdaugh did that will never come into evidence. I think he's going to keep it narrow. I think he's going to keep it centered on what happened around that day. He's going to let the prosecution talk about that. And then he's going to do something else, jury instructions. People often don't focus on jury instructions because they're boring and they're wonky and they're weird. There will be a jury instruction where he says that evidence, where they talked about the financial stuff, you as the jury, you can only consider that for motive. You can only consider it for whether or not it was a reason for him to do this. You cannot say because he did that, he's a bad person who did this. So the judge is going to pound that for the jury too, and he's going to tell them you need to do this. Now, as we all know, people are human. It's like sometimes things will be said in court and there'll be an objection and the judge will sustain the objection and he'll tell the jurors, you're not to take anything from what you just heard. Well, they heard it and hopefully they'll follow the judge's instruction, but they're human. So it's a very difficult thing. It's a very delicate balance, and it will be litigated to the nth degree if there's an appeal in this case.
One thing that keeps coming up, which is neither here nor there, but everywhere, is that people have written to me saying, I understand that the jurors cannot take notes. Alice, do you know? And then I heard that they can take notes, but they've got to leave the notebook with the judge. But I'm thinking to myself, look, I zone out during my own podcast. I can't imagine being a juror, right? And you're hearing all this evidence every day. The things that are going to stick in my mind, of course, is going to be this guy stole $792,000. This guy's voice is heard on a recording minutes before the murders. I'm going to be just remembering, and that's very counter to, let's say, my wife, who is very detail oriented and could host a podcast and then recite back to you verbatim what everyone says. So, I guess it depends on the juror, but back to my original question, can they take notes? Do you know?
So Brett may know this. I don't know that this part was streamed of the trial, but I would be surprised if the judge did not allow the jurors to take notes. It is up to, that's like an administrative matter that every court can run their courtroom how they'd like. But typically what happens in every courtroom I've been in across the nation, the jurors are allowed to take notes. They are given the actual notepads so that no one can sneak in, their own notepads with notes from other people or anything like that. And they're usually given pencils in court, and they are told to leave their notes on their chairs and they cannot take them out. And here's why. The jurors are not supposed to discuss the case while it's pending with anyone, including each other. So whenever they go out for a break and they leave the courtroom and they go into the jury room where no one else is allowed to speak to them, they have been instructed clearly by the court, and they're probably reminded on a daily basis that they cannot discuss the case. They can talk about the weather, they can talk about their lives, but they cannot talk about the evidence or what they thought about each witness. That is incredibly important. And the whole point of that instruction is for everyone to hear all of the evidence, not be swayed by anyone else's interpretation of that evidence until the very end, when all of that evidence has come in, when you've had all of the prosecution's evidence, all of the way it's been challenged, and all of the defense's evidence and all the way it's been challenged, so that you have kind of you're trying to do as much of a blank slate as possible, along with the not discussing with each other. They're not supposed to get on social media. They're not supposed to watch the news. They're not supposed to read anything anyone in the outside world has written or said about this case, including podcasts. That's why you often hear of sequestering the jury, right? Like the OJ jurors, they had to stay in a hotel room by themselves. There's different ways to sequester a jury pool, and the whole point is to keep them in a bubble. So I say all that to say there is a principle behind why maybe some people are saying, oh, they're not allowed to take notes. It's not that they're not allowed to take notes. It's that they can't remove anything from the courtroom because they are not supposed to discuss the case while it's pending with anybody. They can refer back to their notes, but even if they are allowed to take notes, there will be a jury instruction. We kind of keep going back to this, where the judge will instruct each of the jurors. Some of you may have taken notes. You did not have to take notes. But if you took notes and the notes differ from what you now remember, your memory governs. So your notes are only as good as your own memory. And that's an important instruction, because what you take away may be more fulsome than what you've been able to write down on paper. And that's something that you'll hear in every courtroom. In a trial this long, you can imagine that notes you took on the first day may have lost meaning because of other evidence that's come in, other cross-examination that's come in. And so this is all a very complex web, but attacking the whether they can take notes, I think you can now see how it's part of a bigger issue of making sure the jurors are untainted as they take in all the evidence. And then when they are given that final jury instruction and sent back to deliberate, that's the first time they can actually speak about the evidence they've heard throughout trial.
We are going to kind of get to some viewer questions and comments and then wrap this sucker up just real quickly. So there was a guy named Dylan Hightower. He was called to testify on Thursday. He's an investigator that found Maggie's cell phone. The cell phone was found about a half a mile away in a wooded area. And he also testified that some information was deleted from Alex's phone. And then Chris Wilson, who we mentioned previously, this friend of Alex Murdaugh, he sobbed. He cried pretty substantially on the witness stand multiple times, basically saying that he was afraid that Alex might try to kill himself and that Wilson himself was owed $192,000. To you, Brett, the significance, if any, of this cell phone being found a half mile away, what do you make of it?
Well, I think the defense is going to try and argue that that was the killer, and essentially, and I think they've already kind of said this, that they were driving down the road and Alec tried to call her, and they picked up the cell phone because there's all this stuff about when the screen comes on. They saw he was calling and kind of freaked out and threw the phone out the window. That's what they're going to argue. I have no idea why the cell phone's there, and this is something. Another thing about trials and another thing about murders. There are going to be people who will say things like, well, I'm 100% sure he's guilty, but I don't think I could vote guilty because I don't really know what happened to the cell phone. Like they'll grab on to some issue that actually doesn't matter. We're never going to know everything that happened that night, and we're never going to know exactly why it happened. I have no idea why he would delete calls to her off his phone. The calls to her seem like they would help his alibi. So it's weird to me that he did that. I don't know why he did it, and we may never know unless he tells us. But I think there's going to be a lot of that kind of stuff that comes out through the case, and people are just going to have to try and sort of compartmentalize. The defense is always going to try and make huge hay out of that, things we can't explain. An example we often use is in the Manson trial. In the Manson trial, there was a pair of glasses found at one of the murders, and the police for a very long time thought that these glasses belonged to the murderer. Thought it was a key piece of evidence. Then they arrest the Mansons and figure out it doesn't belong to any of them. And they never actually figured out where the glasses came from. And Manson, for forever, always pointed to those glasses as if that was the real killer. It wasn't me. It wasn't our people. It was whoever wore those glasses, right? And it's just a mystery that we don't know. And there's going to be things like this in this case. I would point out one thing about Chris Wilson. That was another piece of testimony that happened in camera. So he gave a lot of emotional testimony, but the jury didn't see any of it. So I guess we're going to have to see whether or not he ends up having to testify again, and this time in front of a jury, about all of that information.
I just had Dr. Henry Lee on the show, the preeminent forensic scientist from the OJ trial, and he said to me, in regards to what you were just saying about the glasses, he said, look, there was another bloody footprint at that crime scene, at the OJ crime scene. And I went, could it be? I don't know. Like he put that doubt back in me, which was kind of insane. And he just goes by the science. But I tell it every time a prosecutor talks, you say something, Brett, I go, great point. And then I hear a defense attorney and I go, great point. So I'm easily swayed. What can I tell you? Let's get to some STS Nation comments real quick. Then I will let you guys go. You've been very charitable with your time. This one comes from Gina White, and this is just to show how everyone's got a theory here. And Alice, I'll toss this one to you. Gina writes, I don't think he actually pulled the trigger. I think he hired a couple of people to pull the trigger. All you have to do is trace the phones and understand what happened there. She could be a juror. How do you, if you're the state, how are you dealing with someone like Gina?
There's no evidence of that, right? A lot of people come up with theories and you have to look at the evidence. And so there's been opening statements, but the closing argument is where you bring it all together. Right now, we hear evidence as it comes in only through the custodian or the witness that that they're allowed to talk about. So one witness can't tell the whole story. Generally, you hear from the phone custodian, you hear from the shotgun expert, but it is the duty of the prosecution to bring it all together in the end and to address those kinds of concerns. You can't address everything, but really what you're trying to pound is that, is it possible that there was another person? Why is there no evidence of another person? Why was another person not heard on the phone? We hear 3 voices. We don't hear 4 voices. We don't hear 5 voices, something like that. So you can't address everything, but you try to pound into people's minds is that, what does the evidence show? What we always talk about on our podcast, Occam's razor. What is most likely? Of course, there can be anyone told to just close their eyes and write up a theory can come up with a theory, but does it match the facts? Is it what likely happened in this case? And you try to bring people back to earth and explain what reasonable doubt is. Reasonable doubt isn't just that it's a possibility in the universe. There has to be some real doubt that you can tie that theory to. You're going to get people like that all the time. And part of the reason we do our podcast is to educate the common juror, right? The juror is made up of your peers. And if we have an uneducated jury pool, you get kind of these wonky verdicts. And I think it's all of our duties to understand what reasonable doubt is and to understand, how the trial system works, because we are all the jury of our peers when we, could be sitting on that same jury.
And I want to say something about that as well.
Hop in, Brett.
Number one, he's still guilty. I mean, even if he hired somebody to do it, he'd still be guilty of murder. And so I don't think it actually matters when it comes down to the verdict. But the other thing is, I've wondered the same thing. So I'm with her. When the fake suicide, he didn't shoot himself. He got one of his lackeys to do it. That fell apart pretty fast. But one of the things the defense is going to talk about is there are 2 guns here. It's pretty rare for one person to use 2 guns, 2 very different guns, to kill 2 people. And could it be that Murdaugh, he goes down there, he makes sure that his wife and his son are in the kennel, he says bye, he gets in his car to drive away, and that's the signal. And when he does that, the killers come in and kill them. Could be. I mean, that wouldn't shock me, right? And in some ways, that works with some of the evidence a little bit better. Ordinarily, it's pretty hard to pull off the murder for hire scheme, especially if you got 2 different murderers. A lot of times that's going to fall apart. But I don't think that's a terrible conspiracy theory. And in some ways, I think one reason it's attractive is for the reason we've been talking about. It's just so hard to imagine taking a 12-gauge shotgun and shooting your son twice with it. It's just hard to imagine doing that. And so the idea of hiring someone just feels better. One thing I would say that cuts against it, it really feels like this was planned, but spur of the moment. It really feels like everything that happened that day is what led him to do it. So that would be pulling together an assassination, murder for hire plot pretty quickly.
Yeah, that is tough to do. We had Amy Zimmer check on. She is the counsel representing Cousin Eddie, the man who tried to pull off that attempted fake suicide, I guess is what you would call it. And Alex Murdaugh has since accused him of the murders, to which she says, absolutely no way. So an interesting take from her. But this comment comes from a friend of the show, Chico's Mummy. She writes, and Alice, I'll let you take this one. I think the prosecution needs to think carefully about what they are doing by introducing the financial motive. It's not adding up very well. It feels like they are scraping the barrel because they have no direct evidence. Juries love motives, but they need actual evidence too. It could also lay the foundation of a mistrial because he hasn't been convicted of the financial crimes. What say you, Alice?
One of our favorite topics, people who think that direct versus circumstantial evidence is weighed differently in court. And we pound this over and over. Direct evidence is if someone sees you do something. So I see you pull the trigger. That's direct evidence of it. We have a camera showing you do that. Everything else is circumstantial evidence. your DNA, your fingerprints left behind, your hairs left behind, the case shells, the Snapchat, everything else is circumstantial evidence. And in the court of law, circumstantial evidence is just as weighty as direct evidence. And we often say this. Circumstantial evidence, especially when you have a mountain of it, is often more compelling than direct evidence because direct eye testimony is so faulty on so many levels. And in a case like this, if you say that there are only 3 people at the kennel, there's not going to be direct evidence. You killed your direct evidence is what happened. And so the fact that this is a circumstantial case, almost every case is circumstantial, and the mountain of circumstantial evidence doesn't mean that they have a weak case. If anything, it's a very bolstered case. It's very supported. The financial crimes, he doesn't have to be convicted of financial crimes in order for them to come in. Remember, this isn't going to whether he is guilty of the financial crimes. It's what was going on in his mind that day. When he got that letter, when he was contacted by his law firm, the law firm that his great-great-grandpappy started, his name is in the law firm. I mean, he is the town, he is the law firm. And they're coming to him and saying, what say you about this nearly $800,000? It doesn't matter whether he actually took that $800,000. All that matters is that conversation happened because it is the impression it made on his mind and how it may have affected him that day. So it does not matter at all if at the end of the day, he is completely acquitted of that particular financial crime charge. What matters is the effect it had on the listener, which is Murdaugh. So I'm not worried about that because the whole point is to show what could make a man snap in that moment. What happened that day that made this the day that he decided to pull the trigger against his family?
2 more quick comments, and then we'll go to closing arguments. How about that? Patricia Blue, Brett, to you. I've never heard of a trial within a trial. She's obviously talking about admitting this financial evidence and creating a second trial. Have you ever heard of a trial within a trial? Is it more common than we think, Brett?
It happens all the time. I mean, anytime you want to bring in evidence like this, it happens. One of the reasons for limiting 404B evidence is to avoid the trial within a trial. One thing, you don't want to have a situation where the evidence itself is so weak, and this kind of goes back to the last question the lady asked. You don't have to have been convicted of it, but you got to have pretty strong evidence that it happened. I mean, it's got to be clear and convincing, is what you keep hearing from the judge. He's saying that clear and convincing evidence that this happened. And if you don't have that, then you don't want to have a situation where there really is a real question about whether this bad thing you're trying to bring in even occurred. In this case, it obviously occurred. It obviously occurred, and as Alice said, even if there's some explanation, it clearly was on his mind that day, and it's going to come in. But these in-camera type things, these discussions, they happen a lot. Sometimes they'll happen actually before the trial. You'll see that sometimes where they'll go ahead and put on some evidence to determine whether or not it should come in. I think one reason that didn't happen here, there are so many different witnesses. It would have really been a full trial before the trial to do that. So I think the judge is sort of seeing how the evidence has come in. He's listening to witnesses. I actually think at some point he will cut this off. I don't think the prosecution will end up putting on everyone that they say they're going to, because I think the judge is going to narrow it. We'll know a lot more tomorrow. The judge has said that the jurors are not to come in, I think, until 11:30 or so. So we're going to hear more about this. And I just feel like the judge is going to start moving this towards a conclusion where he gives sort of definitive guidance to both sides. This is what it's going to be. And the sooner the better, because both sides are going to have to build some strategy around this. The prosecution, when they're limited in what they can bring in, they're going to have to build some strategy about how to present it. And the defense, obviously, will be deeply affected by what comes in. And they're going to want to have plenty of time to figure out exactly how they're going to deal with it and exactly how they're going to challenge it. So the sooner the better. And I think you'll hear it soon, but this is not that unusual.
And a tiny bit of context here for this last comment for Alice. I just had a gentleman on named Kim Varner. He's been practicing criminal defense law since 1979. Sharp as a tack, very bright gentleman. He was on with his son. He said, and this is a response to that, this comment comes from John Relihan, and I quote, "It has all the makings of the cartel." Wow. That is what Kim Varner said. As a criminal defense attorney, it has all the makings of the cartel, that maybe he owed money, he was a drug addict. How would you respond to that as a prosecutor?
It's a really good defense comment because that sounds really sexy.
Yeah. Two weapons.
Maybe,
Yeah.
yeah, too sexy. I mean, sure. If I were a defense counsel, I'd make as fantastical of a story that removes my client from the situation. But again, you have to look at the evidence. Everything could be pointed to a cartel, or this could be a man who was at the kennels with access to a lot of long guns on his own property, his own gated property at that, which is at the back of his property, not visible from the streets, as you hear him say on the 911 call. And if this were the cartel, you would think that his own testimony would sound a little different when he's being interrogated by the police. So this kind of goes back to anyone can write a story, but we haven't really seen any evidence of that. But that's a great argument.
I think I'm going to get shirts made up that say "Too sexy for the Murdaugh trial." I think my entrepreneurial whatever is going right now. Brett and Alice, they host the Prosecutors podcast and legal briefs. You can tell they've got two brilliant legal minds. Brett, your closing thoughts, your closing argument. Does this, and I've asked other people, does this end, in your opinion, in an acquittal, hung jury, conviction? Too early to tell. And what are you looking for next?
I think it's a conviction. I don't. That the video was so damning. I was watching it with my wife, who doesn't follow any of this stuff as much as I do. And when you heard his voice, I mean, she looked at me in shock because she didn't realize it was coming. She didn't hear the prosecution's opening argument. She looked at me in shock and she was like, "Oh, he totally did this." And I feel like there was a lot of that going through the jury. The next most important thing will be this financial information, what comes in and what doesn't. And then after that, I think it's just more sort of the drumbeat of circumstantial evidence. The fact that these, the gun that the cartel, I guess, stole his own gun to do this, a gun that there's ammunition on the property from earlier shooting that matches ammunition used in the murders. It's the evidence here is we're 9 days into this. Who knows how long it's going to go? The evidence is already overwhelming. He will be convicted. By the way, I think, and I might be wrong, but I think I read that Alice went to Yale. So I won't ask who got the higher LSAT score. I'll leave that out of this, Brett. Did you go to Yale too, Brett? I went to Harvard. I went to the better.
You went to the lesser one.
I stand corrected. By the way, Brett is using a Southern accent since we are doing this about a trial in the South. So I appreciate that, Brett. Alice, is this hung jury, acquittal, conviction, and what are you looking for in the next couple of days?
Sure. Just to give your listeners something a little bit different before I answer your question, the lawyers are great at doing this. Look, there are shocking bombshells every day for us who are watching the trial. None of this is shocking for the defense. There is absolutely no surprise for them. They know exactly what's coming because of Brady. The prosecution has to turn over all evidence well in advance of trial. There have probably been overtures of plea deals. There's probably been negotiations, and probably all completely rebuffed by the defense. Because when you are convicted of a crime, you have the right to go to a jury trial. So Alex Murdaugh is going into this trial with eyes wide open. I know we're talking, everyone's playing bingo with how many times he's crying and gasping for air as he hears things. Nothing is a surprise. I cannot emphasize that enough. There is no Perry Mason moment in a trial. If there were, it would be a mistrial, because absolutely the defense will jump up and say, "Your Honor, this is the first time we're hearing of this." Not only do they know exactly who the prosecution is going to be put up, because the prosecution has to reveal their witnesses list well in advance of trial, they have to tell the defense what they anticipate each witness to testify about. They've given over all of their exhibits, probably ahead of time, marked in the order it would come in. And the defense has looked at that exhibit list and said, "Middle finger to you. We're not stipulating to any of it because that's a tactic to bore the jury to death." They know everything in the prosecution's playbook, and that is by design of the justice system. No one wants to be surprised in a murder trial. I say all that because you go to trial when you're actually innocent, and you go to trial when you're so so guilty because you are hoping you can pick off one juror, that black box of a jury who can't speak to anyone in the outside world, can't watch media coverage, and can't talk to each other until they go back there. And you just need to pick one juror off who says, I don't care. I don't care. I don't even care if he did it. I'm not going to say he's guilty because I don't believe in that. That's all you need. The jury never has to explain themselves. Where do I think Alex Murdaugh falls? I think he's incredibly guilty. He should be convicted, but he's rolling his only chance of getting out of this, which is hoping to pick off one juror for whatever reason who will refuse to convict and to maybe have a hung jury and to have a mistrial. That's what I think he's going for.
Very well put. While you were talking, I was listening and Googling, and I will read this aloud. When Harvard and Yale met in 2022, it marked the game's 138th all-time meeting. Yale defeated Harvard 1914. The Yale Bulldogs hold a 69-61, so 69 wins, 61 loss, and 8 ties in their head-to-head edge in the all-time series. So, sorry to tell you, Brett, but Yale is ahead, up by 8 wins so far.
I blame the refs.
There's always next year. But listen, thank you so much to both of you. You better listen to the Prosecutors podcast and legal briefs. Now you know why we have the best guests. Any Twitter handles you guys want to plug, or Instagram handles? Not your kids.
We're at Prosecutors Pod for everything, so you can find us there. And we look forward. And look, hey, I'm sure lots of people disagree with us on some of the things we said. We look forward to having that conversation with everybody listening.
We'll get comments. A quick programming note: we'll be back next week. We are following the Alex Murdaugh trial from beginning to end, and all the latest on what's going on in Idaho and any other crazy true crime news. But for now, love you, America.